Hello to all my dear friends. If you want to learn something, then you have to try to revise that particular topic as many times as you can. In today's video, I'm going to read all the sections from 1 to 167 of Indian Evidence Act 1872. It will help me as well as you to remind all the sections in our mind. So you have to do nothing, just sit comfortably wherever you want in a good posture, close your eyes and try to focus on my voice. So here we start. The Indian Evidence Act 1872 Part 1 Relevancy of Facts. Chapter 1 Preliminary. Section 1 Short Title, Extent and Commencement. Second, Reappeal. Section 3 Interpretation Clause, which includes quote, fact, relevant, fact in issue, document, evidence, proved, disproved, India, certifying authority, electronic signature certificate, electronic form, electronic records, information, secure electronic record, secure digital signature, subscriber. Section 4, which includes may presume, shall presume, conclusive proof. Chapter 2 of the relevancy of facts. Section 5 says evidence may be given of fact in issue and relevant facts. Section 6 relevancy of fact forming part of same transaction. Section 7 facts which are the occasion, cause or effect of fact in issue. Section 8 motive, preparation and previous or subsequent conduct. Section 9 facts necessary to explain or introduce relevant facts. Section 10 things said or done by conspirator in reference to common design. Section 11 when facts not otherwise relevant become relevant. Section 12 in suits for damages, fact tending to enable court to determine amount are relevant. Section 13 facts relevant when right or custom is in question. Section 14 facts showing existence of state of mind or a body or bodily feeling. Section 15 facts bearing on question whether act was accidental or incidental. Section 16 existence of course of business when relevant. Section 17 admission defined. Section 18 admission by party to proceeding or his agent by suitor in representative character. Section 19 admissions by persons whose position must be proved as against party to suit. Section 20 admissions by person expressively referred to by party to suit. Section 21 proof of admissions against person making them and by or on their behalf. Section 22 when oral admissions as to contents of document are relevant. Section 22A when oral admission as to content of electronic records are relevant. Section 24 Section 23 admissions in civil cases when relevant. Section 24 confession caused by inducement, threat or promise when irrelevant in criminal proceeding. Section 25 confession to police officer not to be proved. Section 26 confession by accused while in custody of police not to be proved against him. Section 27 how much of information received from accused may be proved. Section 28 confession made after removal of impression caused by inducement, threat or promise relevant. Section 29 confession otherwise relevant not to become irrelevant because of promise of secrecy, etc. Section 30 consideration of proved confession affecting person making it and others jointly under trial for same offense. Section 31 admissions not conclusive proof but may stop. Section 32 cases in which a statement of relevant fact by person who is dead or cannot be found, etc. is relevant. Section 33 relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated. Section 34. Entries in books of account, including those maintained in an electronic form when relevant. Section 35. Relevancy of entry in public record or an electronic record made in performance of duty. Section 36. Relevancy of statements in map, charts and plans. Section 37. Relevancy of a statement as to fact of public nature contained in certain acts or notification. Section 38. Relevancy of statements as to any law contained in law books. Section 39. What evidence to be given when statement forms part of a conversation, document, electronic record, book or series of letters or papers. Section 40. Previous judgments relevant to bar a second suit or trial. Section 41. Relevancy of certain judgments in probate, etc. jurisdiction. Section 42. Relevancy and effect of judgments, order or decree other than those mentioned in Section 41. Section 43. Judgments, etc. other than those mentioned in Section 40 to 42 when relevant. Section 44. Fraud or collusion in obtaining judgment or incompetency of court may be proved. Section 45. Opinions of expert. Section 45A. Opinion of examiner of electronic evidence. Section 46. Facts bearing upon opinions of expert. Section 47. Opinion as to handwriting when relevant. Section 47A. Opinion as to electronic signature when relevant. Section 48. Opinion as to existence of right or custom when relevant. Section 49. Opinion as to usage, tenant, etc. when relevant. Section 50. Opinion or relationship when relevant. Section 51. Grounds of opinion when relevant. Section 52. In civil cases, character to prove conduct imputed irrelevant. Section 53. In criminal cases, previous good character relevant. Section 53A. Evidence of character or previous sexual experience not relevant in certain cases. Section 54. Previous bad character not relevant except in reply. Section 55. Character as affecting damages. Now part second on proof. Chapter 3. Facts which need not to be proved. Section 56 says facts judicially noticeable need not to be proved. Section 57. Facts of which court must take judicial notice. Section 58. Facts admitted need not to be proved. Now chapter 4 of oral evidence. Section 59 says proof of facts by oral evidence. Section 60. Oral evidence must be direct. Chapter 5 of documentary evidence. Section 61 says proof of contents of documents. Section 62. Primary evidence. Section 63. Secondary evidence. Section 64. Proof of documents by primary evidence. Section 65. Cases in which secondary evidence relating to documents may be given. Section 65A. Special provisions as to evidence relating to electronic record. Section 65B. Admissibility of electronic records. Section 66. Rules as to notice to produce. Section 67. Proof of signature and handwriting of person alleged to have signed or written document produced. Section 67A. Proof as to electronic signature. Section 68. Proof of execution of document required by law to be attested. Section 69. Proof where no attesting witness found. Section 70. Admission of execution by party to attested document. Section 71. Proof when attesting witness denies the execution. Section 72. Proof of document not required by law to be attested. Section 73. Comparison of signature, writing or seal with others admitted or proved. Section 73A. Proof as to verification of digital signature. Section 74. Public document. Section 75. Private documents. Section 76. Certified copy of public documents. Section 77. Proof of document by production of certified copies. Section 78. Proof of other official documents. Section 79. Presumption as to genuineness of certified copies. Section 80. Presumption as to documents produced as record of evidence. Section 81. Presumption as to gazettes, newspapers, private acts of parliament and other documents. Section 81A. Presumption as to gazettes in electronic form. Section 82. Presumption as to document admissible in England without proof of seal or signature. Section 83. Presumption as to maps or plans made by authority of government. Section 84. Presumption as to collection of laws and reports of decisions. Section 85. Presumption as to powers of attorney. Section 85A. Presumption as to electronic agreement. Section 85B. Presumption as to electronic records and electronic signatures. Section 85C. Presumption as to electronic signature certificates. Section 86. Presumption as to certified copies of foreign judicial records. Section 87. Presumption as to books, maps and charts. Section 88. Presumption as to telegraphic messages. Section 88A. Presumption as to electronic messages. Section 89. Presumption as to due execution etc. of documents not produced. Section 90. Presumption as to documents 30 years old. Section 90A. Presumption as to electronic records 5 years old. Now chapter 6 of the exclusion of oral by documentary evidence. Section 91 says evidence of terms of contracts, grants and other disposition of property reduced to form of documents. Section 92. Exclusion of evidence of oral agreement. Section 93. Exclusion of evidence to explain or amend ambiguous document. Section 94. Exclusion of evidence against application of document to existing facts. Section 95. Evidence as to document unmeaning in reference to existing facts. Section 96. Evidence as to application of language which can apply to one only of several persons. Section 97. Evidence as to application of language to one of two sets of facts to neither of which the whole correctly applies. Section 98. Evidence as to meaning of illegible characters etc. Section 99. Who may give evidence of agreement varying term of document. Section 100. Saving of provisions of Indian Succession Act relating to wills. Now part 3. Production and effect of evidence. Chapter 7 of the burden of proof. Section 101 says burden of proof. 102. On whom burden of proof lies. Section 103. Burden of proof as to particular fact. 104. Burden of proving fact to be proved to make evidence admissible. Section 105. Burden of proving that case of accused comes within exception. Section 106. Burden of proving fact especially within knowledge. Section 107. Burden of proving death of person known to have been alive within 30 years. Section 108. Burden of proving that person is alive who has not been heard of for 7 years. Section 109. Burden of proof as to relationship in the cases of partners, landlord and tenant, principal and agent. Section 110. Burden of proof as to ownership. Section 111. Proof of good faith in transaction where one party is in relation of active confidence. Section 111A. Presumption as to certain offences. Section 112. Birth during marriage. Conclusive proof of legitimacy. Section 113. Proof of cession of territory. Section 113A. Presumption as to abatement of suicide by a married woman. Section 113B. Presumption as to dowry death. Section 114. Court may presume existence of certain facts. Section 114A. Presumption as to absence of consent in certain prosecution for rape. Chapter 8. Estoppel. Section 115 says estoppel. 116. Estoppel of tenant and of licensee of person in possession. Section 107 estoppel of acceptor of bill of exchange, bailee or licensee. Chapter 9 of witnesses. Section 118 who may testify. Section 119 witness unable to communicate verbally. Section 120 parties to civil suit and their wife or husband or wife of person under criminal trial. Section 121 judges and magistrates. Section 122 communication during marriage. Section 123 evidence as to affairs of state. Section 124 official communication. Section 125 information as to commission of offences. Section 126 professional communications. Section 127. Section 126 to apply to interpreters, etc. Section 128. Privilege not waived by volunteering evidence. Section 129. Confidential communication with legal advisor. Section 130. Production of title deeds of witness not a party. Section 131. Production of documents or electronic records which another person having possession could refuse to produce. Section 132 witness not excused from answering on ground that answer will criminate. Section 133 accomplice. Section 134 number of witnesses. Now chapter 10 of the examination of witnesses. Section 135 says order of production and examination of witnesses. Section 136 judge to decide as to admissibility of evidence. Section 137 contain examine in chief, cross-examine, re-examine. Section 138 says order of examination and direction of re-examination. Section 139 cross-examination of person called to produce a document. Section 140 witnesses to character. Section 141 leading questions. Section 142 when they must not be asked. Section 143 when they may be asked. Section 144 evidence as to matters in writing. Section 145 cross examination as to previous statements in writing. Section 146 questions lawful in cross examination. Section 147 when witness to be compelled to answer. Section 148 court to decide when questions shall be asked and when witness compelled to answer. Section 149 question not to be asked without reasonable grounds. Section 150 procedure of court in case of question being asked without reasonable grounds. Section 151 indecent and scandalous questions. Section 152 questions intended to insult or annoy. Section 153 exclusion of evidence to contradict answers to questions testing veracity. Section 154 question by party to his own witness. Section 155 impeaching credit of witness. Section 156 questions tending to corroborate evidence of relevant fact admissible. Section 157 former statements of witness may be proved to corroborate later testimony as to same fact. Section 158 what matters may be proved in connection with proved statement relevant under section 32 or 33. Section 59 says refreshing memory when witness may use copy of document to refresh memory. Section 160 testimony to facts stated in document mentioned in section 159. Section 161 right of adverse party as to writing used to refresh memory. Section 162 production of documents, translation of documents. Section 163 giving as evidence of document called for and produced on notice. Section 164 using as evidence of document production of which was refused on notice. Section 165 judges power to put questions or order production. Section 166 power of jury or assessors to put questions. Chapter 11 of improper admission and rejection of evidence. Section 167, no new trial for improper admission or rejection of evidence. So this was the whole Indian evidence index of whole Indian Evidence Act, and it is not mandatory for you that you have to listen my voice only. You can record your own voice, and this technique, you can use this technique in different subjects also. So you have to record your own voice, and once a day before going to sleep you can listen that voice, and after few days you will realize that you have already know the whole concept of that topic. So thank you.